This was the most one-sided battle of the experts, I believe, perhaps in the history of court TV. The most one-sided battle of the experts when it comes to the accident reconstructionists in the KarenRead case. This was absurd. This was beyond. This was worse than in the Alec Murdaugh case when the defense was trying to, their expert was trying to tell us that the shooter was 5'2", right? This was a complete annihilation from top to bottom. So I think the question for us today, as the defense is rested and we're getting ready for closing arguments tonight at 8 and then tomorrow in Massachusetts, is what does this mean? What is the impact of this? Because I cannot believe that anyone watching would think anything differently. I can't believe anyone watching would think anything differently about the experts in this case and trying to reconstruct what happened and try to explain to the jury what could or what could not have happened here. And it starts with who was delivering the information. On the one hand, you had a trooper clearly connected to the Commonwealth. You know, it happens all the time. I had experts when I was a prosecutor who worked for the prosecutor's office. Absolutely did. They were experts in what they in their fields. But in this case, it's a bad look because of the level of experience, the level of education, and the lack of science. Right? This was a case, and this is why I was flabbergasted initially to a certain extent, but today became much, much, much clearer. Like, wow, I can't believe that the prosecution would rely upon an expert who has none of the background or science or equations that go into accident reconstruction all the time. Like every day in courtrooms and in depositions from coast to coast. Do you know how many car accident cases there are being litigated in this country and how many qualified experts there are out there in this country putting together the pieces and the evidence to tell a story to the jury and then backing it up with a scientific basis, like physics might have a little bit to do with it. Unreal. It didn't it only happened on one side in this. And then you take it one step further, it comes from experts who are not even paid by the defense. It's embarrassing. It's absolutely embarrassing. And that's where they left. In a case that is this important and this serious, they didn't provide that part of the case that I'm sure the jury may very well want. See, to me, the big impact of this battle of the experts, this annihilation of an expert that is one-sided, is that it allows the jury to feel much more comfortable in saying those two words, not guilty. Either verdict is difficult for the jury. They need to lean on something and hear what the defense has handed them is an opportunity to say, well, we heard from the experts and, one set of experts, a lot more qualified and experienced and able to explain things and use science and math and equations to figure this thing out. And that came from the defense, who doesn't have the burden here, right? Like that's the expert, the type of testimony you would want from the people who have the burden of proof. It always comes back to burden of proof. At this point of the trial, at this part of the case, the story, everything else, it's all about what this jury is going to do. And what this jury is going to do is based upon the instructions that they will get from the judge. And it's clear what the case ends up being about. Did this prosecution team, did the Commonwealth meet their burden of proof? It's not, did the defense prove there was a conspiracy? Because they didn't. But did the prosecution meet their burden of proof, which is the standard. That's how it works in our system. That's what criminal trials ultimately are about. And that is the moment that we are in right now. We are in the moment of they will make their closing arguments. There will be no more evidence. I don't think there's going to be any sort of rebuttal case. If there is, it's going to be super quick. But the jury will make their decision based on the evidence they have in front of them. Now, some of the evidence is eyewitness testimony, obviously, physical evidence, pieces of the taillight, DNA, things like that, and then expert testimony as well. And they can weigh all of it. But if you're weighing the expert testimony in a case where no one witnessed what actually happened here, right? No one witnessed the alleged crime. So the closest you will have to a witness to the crime will be the expert who will explain how the evidence paints that picture. But that picture was not, I mean, it was very, they were just giving conclusions. The prosecutor was just giving conclusions. He wasn't really backing it up with the type of analysis and expertise that you expect from an expert. Not like, oh, I looked at this, I asked what it looked like, I followed the pieces of glass, and then he was thrown 30 feet. Whoa, wait a minute. How did all that happen? Give me some numbers. Let's talk about force. Let's talk about weight. Let's do something here. But the prosecution didn't. And the conclusions of the defense were very clear today. That the evidence isn't there, but it's clear that there's no evidence to prove what the prosecution is saying happened through their expert. That he jumped over the all the evidence that you needed and just got to his conclusion. But it's got to be backed up. There needs to be a true foundation. Now, this again, ladies and gentlemen, do not confuse different things here. Okay? Do not confuse different things here. There is a criminal trial, which is about a prosecutor, the state, or the Commonwealth proving someone committed the crime beyond a reasonable doubt. That's what the trial is about. Unfortunately, it's a search for the truth. And sometimes we get to the truth when there is a conviction, right? When there's a conviction, then the jury has spoken and they have spoken the truth. But if the jury comes back and says not guilty, that doesn't answer the question. The question remains unanswered. And not guilty does not mean innocent. Remember that. Those are two completely different things. There's a presumption of innocence that we all get versus actual factual innocence. I didn't do it, someone else did. Right? Now, I didn't do it, someone else did is not what you need to prove as a defendant. It's not what the verdict means. The verdict means the prosecutor did not prove it. That doesn't mean they arrested or charged the wrong person. It doesn't mean that the people that the defense said did it. It doesn't mean anything. It means the question now remains unanswered. But before we even get there, but to me, that's just framing what this discussion is about and what a trial is about, because that's what we are in right now. Now, the court of public opinion and the story and what actually happened here may not be answered by this jury. May not be answered by this jury. The only time they answer that question is when they say guilty, because when they say guilty, they are telling us that the evidence is to such an extent that, yes, this is the person who did it, and that is what happened. So let's see. Let's see what they come back with. Now, the jury can reach that many different ways. You can reach that through expert testimony, but that's not going to happen in this case. The expert is not going to win the case for the prosecution. The expert might win the case for the defense. That may be the doubt in and of itself. The testimony of the expert reconstructing what happened there by itself could be the reasonable doubt in this case. That could be the manifestation of the doubt in one or more jurors' minds. Now, prosecutors can still prove their case if they can get the jury to discount or minimize the impact of the battle of the experts and rely upon eyewitnesses. Now it becomes, does the jury trust the people in the house? Does the jury trust the lead investigator as to what they testified to seeing, hearing, and finding beyond a reasonable doubt? That's how deep the trust has to be. So then prosecutors can win the case there. They have witnesses who are saying things. The question is, will the jury trust them and believe them beyond a reasonable doubt? Okay, so they can. That's the other way this jury can come to their conclusion. You also have this alleged confession by KarenRead. Does the jury believe that? Does the jury trust that? That can be enough for them to get to some of the charges in the case. That alone can be enough evidence if they believe that it is a confession and they believe it beyond a reasonable doubt. So that's where we are. And this, you see, when you're prosecuting a case, you want to tie up all your evidence. You want all your evidence pointing one way, and it's not. It's not. The expert testimony is pointing a completely different direction. And that is a huge problem because it gives one or more jurors something to hang their hat on. If they believe there's some doubt, they can say, well, I believe there's doubt, but why? Why is there doubt? Well, the expert, I believe these experts, and these experts had doubts, like real doubts. Like this couldn't have happened the way they're describing, the way they're telling us it happened. Now, you can't discount those experts as hired guns like you can in most cases because they didn't get paid by or work for the defense, as happens with experts in almost every other case. These experts weren't paid by the defense. They weren't hired by the defense. This all came from the federal investigation. Your federal government, your Department of Justice, your FBI, investigating and hiring these folks and giving them evidence and tell us what you think. So they're you can't attack them that way. In most cases, you can attack them, ladies and gentlemen. Yeah, they got hired. You've got to prove it. So now the defense is going to lean heavily now on this expert testimony, obviously, and they'll lean heavily on the mistrust that they have for the lead investigator. And what is the common denominator in these two biggest pieces of evidence or avenues or potential roads to reasonable doubt for the defense? Where did this evidence come from? It all came from the federal investigation. Think about that for a second. This is such an unusual situation. These experts were hired by the feds. Getting into Trooper Proctor's cell phones and getting all that information, those text messages, that all came from the federal investigation. So the best evidence for the defense was not procured by the defense. It was procured by the FBI, the Department of Justice, and your federal government. This is I've never seen this in a case before. Have you? I haven't. So that's where we are. So as we sit here on this Monday, getting ready for Tuesday, which will be closing arguments. By the way, my show is called Closing Arguments. You'll see that at 8:00 tonight on Court TV. But now the pressure is on, and is on both sides. Trust me, there is a lot of pressure on the defense. Rarely does the defense get to closing arguments at this point where you're feeling really good about your case. It's a case where you've never seen so many issues arise. These things don't normally happen. So now there's pressure on you, David Yannetti, Alan Jackson, to close this case. Pressure. You don't want to leave anything out. You want to make sure you hit those themes that the jury will take and use during deliberations. Now, for the prosecutor, he's got to win this case now. It's not like, see, for the defense, it's like it's their case to lose, but the prosecutor has to win this case with his closing argument. Has to win it. Has to put these pieces together in a way that were not necessarily self-evident during the course of his trial. I've seen it done. It can be done. I don't know if the evidence is there. I don't know if the evidence is there to put those pieces together, but I know that no one knows his case better than the prosecutor, Adam Lally. Like, he knows his facts. He knows his witnesses. He knows everything inside out. He's been living and breathing this case. So if there's anyone that can put the pieces together for the prosecution and win this case, it's the man who's been trying this case and the man who knows this case. But he's got to know how to put it together, and he's got to have something that we didn't necessarily think of or put together ourselves. Something where you take a piece of evidence from over here and a piece of evidence from over here, and you put them together in a way that we're like, now it makes sense. Now I get it. That's where he is. He's behind. He needs to win the case, not lose the case, but actually win the case. And the prosecutor gets the last word. So you'll have that chance to do that. If you've got something, it's almost like having a secret weapon at the end of the case. You're going to pull it out and see if you can win it. For the defense, you're going to focus here. You're going to focus here. But I really, and you know, the experts go beyond the accident reconstructionists, like even like the medical examiner. It's not super helpful to the prosecution. It's kind of meh. It's kind of meh. And there are cases like that where it's kind of meh. Yeah, you know, we can't really, through the medical examiner, forensic pathology, really put this case to rest. It just doesn't speak loud enough as to what happened. Now, there are cases with the medical examiner with knife wounds or gunshots, things like that. Easier to go 2 + 2 = 4 in a case like this, but that's not the weapon. The alleged weapon is a car. The alleged weapon is the car. Now, you've got the car in the hands of the defendant, but now you've got to prove that the car was the instrument used. And that's why the expert testimony was so important. Like, even for the prosecution to just have a wash, a clean wash, but it wasn't. It wasn't. And if you think it was, I don't know. You may have been watching something different. I don't know. But to me, you know, having watched hundreds of trials on Court TV through the years, and I usually
It's a battle of the experts. One side's going to say this, one side's going to say that, but let's look at the other evidence in the case, right? But in this case, one side said this, but the other side, said this, and they weren't even getting paid. So that's where we are. So someone was mentioning the poll. So yesterday we had the poll up, and I think it's still running on YouTube for not guilty versus guilty. You can go onto my YouTube page and go into the community tab. Right now it's 87-13 for not guilty, 87-13. And then I have a poll on X as well. Not as many people on it. It's a couple posts below this one. And that's 85-15. 85-15, 86-14. So they're both very similar, the two polls, if you're looking for an update on that. So, and here's the problem, right? So, and I'm looking at some of the questions, like what caused the head injury. That's up to the prosecution. That is your burden to show and to prove to the jury. That's yours. That's in your hands. It's not in the defense to have to prove another way. You need to prove the way you're alleging. And I don't know if they did. Did they really prove that? Now you can the jury can also pull back. They can pull back to like the big vision of the case and say, well, come on, she did it. She did it. And then if they have that discussion in the jury room, it's like, okay, but so what happened here? And she did it, but what happened? Like, your gut can tell you that. Your gut can say, yeah, she did it. Come on, be honest. She was behind the wheel. That's what happened here. Okay. But that's not beyond a reasonable doubt. And that's not what the judge will say the prosecution needs to prove. That's not the standard. That's not how it works. So that's the problem. So, and I did say this yesterday, but I'll say it again today. I said it, was it last night maybe? Trooper Proctor, the focal point of the defense. KarenRead, her actions, her reactions, her statements, the focus of the prosecution. Proctor, the focus of the defense. And this is a case where the prosecution didn't bring all the evidence, didn't present a case the way you would expect. See, prosecutors are allowed to go outside of the Massachusetts State Police if they want to find an expert. Sometimes prosecutors' offices, a lot of times, they will go and they will pay, and just like the defense pays for an expert witness to come in to do this analysis. And no offense to Trooper Paul, but this should not have been his case. Like if there was someone in the Massachusetts State Police who was like the senior person with the most experience, who's done this the most, who has could explain things a lot better, he or she should have been the person doing it. And that falls onto the state police. That doesn't necessarily fall on the prosecutor, although the prosecutor after the fact can go hire someone if they want. Now, here's the other little trick in all of this, is that this federal information came to light late in the game. Like neither side knew about this stuff until late in the game. Some of the most persuasive arguments that the defense can potentially make all came late in the game, despite the fact of what they've been saying all along. This other stuff that came to light is much more potent inside of a courtroom, in front of a jury. So a case that we thought was predicated upon a Google search, you can still make the arguments for it if you want, but to me, it's not about the Google search. It's about meeting the burden of proof. This is a standard case. I said in the beginning when I was covering that this case was different. It's different in many ways, as the trial itself is wrapping up. It's going to come down to reasonable doubt. It's not going to come down to, oh my goodness, I know exactly who did it because of what the defense told me. That's not what happened. That did not happen in this case. This is going to be a traditional reasonable doubt type of case. What makes it different is where the reasonable doubt is coming from and how many different directions it potentially lives. Rarely do defense attorneys have this much to say, this much to argue to a jury. So, and I think that's why overwhelmingly you look at the poll, people who are watching the case, listening to the testimony, taking a look at the evidence, believe that this case has not been proven beyond a reasonable doubt. Hasn't been proven. Once again, getting back to what the trial ultimately is about. So that's where I am today. It's a one side. If the prosecutor can overcome their shortfall in expert testimony, that would be pretty surprising to me. Pretty surprising to me. And that's where Lally would have to surprise me during his closing argument and make some amazing points that have not been made. Because this case has a lot more potential reasonable doubt than I've seen in other cases where the jury has come back and uttered those two words, not guilty. So, we can all believe what we believe about what really happened here. Right now, my analysis of this case after this testimony today is that there's more than enough for a jury to feel extremely comfortable saying not guilty, if that's where they land, right? If that's where they land, there's more than enough that you could point to and say, yeah, okay, I get it. I just have to put this up. This is pretty. No, there we go. We had a lot of comments. Let me get to a few of them. See what direction everyone is kind of going here. As always, saying thank you to Melly and Frankie Figs, and of course Gen X, our great moderators. Gen X with a great point here. They were pretty credible to me, but it only matters what the jury thinks of them in the long run. Yeah, only the jury renders a verdict. Only a jury renders a verdict. And we know that. Here goes Deb. Come on, Vinny. That might have been because I was late, right? I now see the times of these posts. They may have been there the whole time and I never noticed them, but I can see when people are saying what they said. All right, so let's, I start in the beginning and I scroll through and I grab a few here and there. I was running a couple minutes late because those of you who know that I am type 1 diabetic, I have various medical devices that I use and wear, and one of them had to be changed out. So that slowed me down a little bit. I had to change out my medical device. Marissa Charles, so it's rested. Now very sure she did not hit him. So Marissa is clearly in the majority of the not guilty viewers. Let's see who else is checking in. And all right, so now I've got some from when the show actually started. Mm-hmm. Hi, Vinny. Please explain the jury instructions. Well, they're going to have a meeting. So jury instructions is where the judge instructs the jury on what the law is, what the standard of proof is, what the burden of proof is, and what questions they need to answer in order to reach a verdict. Now, there are some instructions. Most instructions are pretty standard, but there are some special instructions that either side may ask for, and there's some unique instructions that the state of Massachusetts may have that they don't have in other states. But generally speaking, most judges have like the standard jury instructions in a book, and then you figure out which ones apply to this case. But you will see attorneys arguing for and against different instructions being read to the jury, but the judge makes the decision. The jury instructions are significant because anytime a judge strays from the standard instructions, there is an ability that a mistake could be made. And if a judge makes a mistake in the instructions and someone is convicted, oftentimes that conviction will be overturned. So this is where the judge is usually straight by the book, straight down the middle, and very conservative in the way he or she, in this case she, will instruct the jury, because you don't want anything that you say as a judge to be used as a reason to overturn a verdict if in fact Karen Read was found guilty. So that's what the instructions are. They are read to the jury before they deliberate. Some judges read them before the closing arguments. Some judges read them afterwards. I think this judge will read them afterwards, but I'm not sure. So the judge, gives them the law. Now, in some states, the judge just reads the instructions to the jury, and then the jury has to remember them. If they don't remember the instructions, they can ask the judge to read them again during their deliberations. Or you can get a written copy in some states with some judges. So I've seen it both ways. We'll see what this judge does. I think the jury should have the written instructions in the jury room, because you're asking them to remember some very complicated legal concepts. And it's tough enough being a juror trying to agree on things, but then to understand what you're supposed to answer and what the questions are and what the definitions of things are that are all contained in the instructions. It's a lot easier, I think, for the jury if the instructions are in the room with them. But not every judge, not every jurisdiction does that. So I hope that gives you a preview of what's happening. And they'll meet to discuss the instructions. I think they're meeting this afternoon. They already met, I believe, about the instructions. Okay, let's see who else is here. And that's from Facebook. Sue Fort from Facebook. Thank you so much, Sue. And Melly, just reminding everyone, stay on topic and play nice. We can disagree without being disagreeable. Don't make it poisonal. Don't make it poisonal. No personal attacks. But you can have a vigorous debate. That's what a trial is. I mean, that's what a trial is, a vigorous debate with rules, right? The judge makes calls. Well, if you're in the if you're in the chat room, Judge Melly, Judge Figs, and Judge Gen X will make the calls. Mm-hmm. Okay, this is from Kate Sharp. Kate says the shoe found in the snow has a black sole. Okay, I've seen that, but let me see if I have. That. Okay, so I do have a picture of the shoes in evidence. And if you look at the shoes these are the shoes that are put in evidence. Now, if you want to argue that they did the old switcherooski, you can make that argument, but these are the ones that have been placed into evidence. This is an evidence photo. So in this evidence photo, both have white soles. So I hope that clarifies that. So it's the jury won't have two different colored shoes in evidence, or a picture of two different colored shoes next to one another. But I think you'd have to argue that at some point someone switched them and is perpetrating a fraud on the court by putting this photo into evidence. So that's where we are on that. Michelle L. Lally tried to trip up Dr. W by saying he doesn't have experience assessing a scene as Trooper does, but in the case, Trooper Paul didn't either. Yeah, I mean, you can. And there was something else that the expert said that I agreed with, which is, and this came through like with the photos, like he said, when he assesses a scene, like he does the wide, takes the wide look and then zeroes in on pieces of evidence. But in this case, it seems there was a lot of zooming in on pieces of evidence that were found without the wider look of where were they all found. Now, there's a ton of pictures that were put into evidence, but I think that's something that you have to do when assessing a scene, is see the whole scene and then bring the camera, bring the investigation in. And the defense expert said, I call him a defense expert because he testified for the defense, but wasn't hired by the defense. But the defense expert had a problem with the way the scene was photographed in this case and investigated. And then Alan Jackson brought out the fact that, well, it wasn't really clear when stuff was found. Matthew Mazzarella, who has a better chance at a civil suit, Karen Read or the O'Keefe family? Great point by Matthew Mazzarella. Now, a civil suit. So a civil suit, Karen Read, for like, if she was found not guilty for, unlawful prosecution, whatever. Now, remember, in a civil case, the burden of proof goes from here all the way down to here. Okay. Well, it's not up here anymore. So if the O'Keefe family and the John O'Keefe estate sued Karen Read for wrongful death, that case, that trial would look and sound a lot different. Number one, Karen Read could be compelled to testify, number one. Number two, and this is like what happened in OJ, number two, the burden of proof is not to prove it beyond a reasonable doubt. It's just preponderance of the evidence, 50.00001%. It's like tilting the scale like this rather than like this. Criminal case, it's like this. Civil case, it's like this. So I believe a better chance at a civil suit would be the O'Keefe family. Karen Read, if she's found not guilty, then, pushing and suing for damages to her reputation. I think it's a tough case. I just think that's a tough civil case. I think for the O'Keefe family, you'd have a lower burden of proof and, an opportunity to actually question the defendant in front of the jury if it went to trial. So I think that would be, they would have a better chance at success than Karen Read would in any civil case. No, because I don't even know what I'm going to be on. I don't even know what I'm going to be on. That's why the mods are so amazing, because my day, I'm just rolling from one thing to the next. And then if I have time, I say, all right, I got a window of time. I'm going to jump on, and I jump on because I really, because of all my other commitments, cannot schedule things regularly or that far ahead of time. So that's the answer to that, Son Jay. Thank you. A little OT, a little BTS behind the scenes. All right, Dan Callahan. The Alberts, McCabe's, Procter & Company were being too evasive, destroying phones and distancing themselves from each other. Unreliable testimony, in my opinion. Okay, so that gets to the second bucket, right? The first bucket is expert. You prove the case by expert. The second bucket is you got to prove the case by witnesses. These are the witnesses who are all saying that John O'Keefe never went inside the house. So do they believe them? Do they believe them? Beyond a reasonable doubt. And Dan is finding their testimony unreliable. So then the last thing that's left is the words and actions of Karen Read herself for prosecutors to prove their case. They can prove it any which way, and I think they're going to lean on Karen Read. I really do. Because that's the only thing they have to do. Mike. Vinny, you ever call your parents at 1 a.m.? Did I ever call them at 1 a.m. back in the day? No. Back in the day, never called them 1 a.m. The only time you would call at that time would be, some sort of family emergency, right? If there's a family emergency, that's the only time. But no. The answer to that is no. Never did. All right, still rolling through here. We've got Biff Thundermuffin. These experts from the feds were only given data favorable to the defense and admitted to it. Their testimony is 100% unreliable. 3,100 pages of evidence from the feds. Only thing is mean texts. Interesting, Biff. And so what does the jury do with that, right? Because the jury doesn't have insight to any sort of a backstory here, right? They just have highly qualified people coming to a conclusion. Do you believe so unreliable? Well, then I think the jury would have to know more of this backstory, but it was hidden from the jury, right? The whole federal investigation, the point was to hide it from the jury. They can't know about it. It's too prejudicial, not probative. So we're going to speak in code in front of the jury. So, this may be the fact, but I don't know if that's the way the jury is going to receive that testimony. But a fair point by Biff. Thunder Muffin. I have a feeling that's just a stage name. Call me crazy. Call me crazy. That may just be a stage name. Mm-hmm. And, best case scenario as a prosecutor, you'd like to win all three, all my witnesses, top notch, credible, conduct, statements, behavior of the defendant incriminating, and my experts corroborating everything that I'm arguing to you. That's your best case scenario. You don't always have that. Sometimes your witnesses are just off because they're people connected to the defendant, right? So sometimes they're could be sketchy. Experts, though, usually the worst the prosecution ever does with expert testimony is a wash. That's the worst that they do, is just a plain wash. Like, okay, you have your experts, the defense had experts, everybody's qualified, everyone's making their points. There's a little bit of gray area in the middle, and it is what it is. I've never seen this where it's this one-sided and lopsided. So haven't necessarily dealt with this situation previously. Blue, no matter what happened that night, I believe Karen will be a free woman soon. Today convinced me the last expert was the final nail to the prosecution. And when we talk about final nails, it's usually we're talking about defendants. Usually we're talking about defendants. And that's not what a lot of folks are saying today. Biff is back. When's the last time you saw the U.S. attorney help a murder defendant get personal phone texts from the investigators to discredit the investigation? Sounds like corruption to me. So what Biff is saying is that the corruption in this case is with the Department of Justice, the federal government. Well, which is fair game, right? If you on the one hand want to attack the Massachusetts State Police, the DA, and everyone else and say, they're corrupt, then I think Biff should be entitled to make an argument that he believes the U.S. Attorney's Office, the FBI, has a level of corruption. And maybe it's all fueled by personal vendetta or politics in Massachusetts, which could be the case. But Biff has really underscored what is made this case very unusual and very different, and has given the defense evidence that they would not normally have access to or the ability to argue to the jury. So great point by Biff. And Kathy today, thank you, Kathy, for the super chat. Thank you, Kathy, for the super chat. That's my Midwest accent. Time to smile. Mick Spunky. Hello, it's Mick Spunky here. Nice to see you, Vinny, mods, and the chat members. Always spreading good feelings and just positive vibes. The one, the only, Mick Spunky. Melly, hello, beautiful humans. Like and subscribe. Do not miss closing arguments tonight at 8 o'clock on Court TV. Yes, yes, yes. I do a show on Court TV every night from 8 to 10. It's 2 hours of live true crime. It's unscripted. It's unpredictable. And we're covering big stories and trials like this and big investigations and cases. Tonight, obviously, we'll be talking about this. And we're also talking about big developments in another case you'd likely be very interested in, which is the disappearance of a woman named Crystal Rogers. That backstory will have your head scratching. And that one has a little taste of potential police corruption because the defendant's brother was a local police officer. So one of the defendant's brothers. So we'll have that for you tonight as well on closing arguments. The Crystal Rogers case. And, geez. It's acting crazy. My scroller was acting crazy. All right, I'm back to where I was. Mark Jasper, did you know about Sandra Birchmore in Canton? Do you know about Sandra Birchmore in Canton? No, I don't. Who is she? Who is she? A reminder here from Timothy Karen, can be guilty in lesser charges. That's part of this case. That's part of, and as a matter of fact, that was the original case, right? So when we get to this verdict, which, could be 24 hours from now, for all we know. You don't know when the jury's coming back. I don't know. I can tell you when an average jury would come back. In a case like this, it's probably like 4 days. But they could come back very quickly if they're all kind of on the same page right out of the box. So, and the guilt, as you're listening to that verdict, you hear the first verdict, keep listening because there's still a lot at stake beyond the top charge in this one. Thank you, Timothy, for reminding us. Timothy watching on Facebook. By the way, we're streaming Facebook, YouTube, Twitch, and X simultaneously. If you're on X, retweet, re-X, and make sure you follow. If you're on Facebook, you need to share it and follow. Thank you so much. And on YouTube, what you got to do is smash the like button, subscribe, hit the bell so you get all the notifications of when I go live. Very unpredictable. To me, some cases I can look at and say, yeah, I'm pretty sure. I think I know where it's going. This is not one of them. Both sides had access to these true experts. The prosecution chose to use Trooper Paul. Enough said. Math wins. Signed a former math major. LOL. Michelle, the mathematician. Thank you, Michelle. Julie Burke. If it's not in writing, it didn't happen. No one documented I hit him. It was an afterthought on their part. She's one. Let me see what percent this is. I got to see how many commas I put in here. Let's see, 1, 2, 3, 7. So if there's 7, is that 10 million% not guilty? I think that's 10 million%. If I'm wrong, someone I'm sure will correct me. Thank you, Julie Burke. Nathaniel Greer. I'm surprised Lally didn't call Dr. Vinny Boombots and Dr. Nick Riveri. You must have went to law school with Lionel Hutz. Dr. Vinny Boombots. You know whose doctor that was, right? Wasn't that Rodney Dangerfield's doctor? Dr. Vinny Boombots? Thank you, Nathaniel. And Carolyn on Facebook, not guilty, not proven. Not guilty, not proven. And that's the legal standard. You got to prove it. If you don't prove it, then it's not guilty. Over 4,000 live viewers right now. Thank you, folks. All right. This is Gadidel Sid. Gadidel Sid. Vinny, are you diabetic? Yes. Type 1. Type 1. I haven't. Can you see this? An insulin pump. I have a glucometer. But right now, I am not getting my readings because I had to put on a new glucometer, and it takes 2 hours for it to warm up. But thank you, Gediddle, Sid. Oh, here we go. Martin, this is great. Vinny, do you get a pain in your butt from sitting on the fence? This is one of those cases. Martin. What I would like to do. I would love to be in a room with 11 other people and try to work this out. Right? Like we all can like sit here by ourselves and say, yeah, this is what I think. Yeah, this is the way I'm going. But when you have that burden of having to reach the verdict and having to agree with 11 people that you never met before, right? It changes the dynamic a little bit. Like we can all be like, oh yeah, this is exactly what I, maybe it's not. Maybe someone could say something in that room that could change your mind. Or maybe you would compromise. I don't know. But yeah, this one did hurt a little bit. Because this was a trial that, but I will say this, today was an unprecedented destruction of an expert by two other experts. That's what today was, from my perspective. There were questions that I wanted answered that the prosecution didn't answer, and the defense came a lot closer. Susie Q, I thought she might be guilty at the beginning, but too much reasonable doubt. Now I think not guilty, period. Susie Q. That's also a little snack. You know, those Susie Qs? You ever have those? Did Hostess make the Susie Qs? Who made this? Who made the Susie Q? There's no one else here. Thank you, Susie Q. Very much appreciated. This is interesting from Hot Pink Thread. My guess is guilty on the third count. A jury can do anything. They can come to any result. They really can. As long as they deliberate and reach it together, boom, there you go. Susie Q, as a dog groomer, those wounds on the arm are obviously dog bites. Says a dog groomer. There you go. Deborah Woods, Smouse. I think it'll be a long deliberation. Well, see, this gets back to Vinny's theorem. See, long deliberation means different things for different trials, okay? So in a long trial like this, 30 days of testimony, although I'd estimate about 10 of those days were only half days, so it's about, 25 days. I think 20, I think we have about 20 to 25 full days of testimony. Is the way we have 30 days of testimony, but I think a full days of somewhere between 20 and 25, which to me, that's 4 to 5 weeks. So for each week of testimony, a normal deliberation takes about a day. So in this case, we have, I would say, at least 4 weeks of deliberations. So if this jury doesn't reach a verdict in 3 days, I would not call that a long deliberation. I wouldn't call it a long deliberation until we got to like day 6, day 7, day 8. So I don't necessarily think it's going to be a long deliberation here. I think it'll be close. Like if they get the case on Tuesday, you go Tuesday, Wednesday, Thursday, boom, 4 days, right? That's right about in conjunction with the Politan theorem, and that puts us on Friday, where 75% of court TV verdicts happen on Fridays. If the jury gets it tomorrow, I'm thinking Friday would be pretty much the normal time that a average jury in an average case would reach the verdict in this case. If we go beyond Friday, I think it's starting to get long. If it's before Friday, I think it's a quicker one. I hope that makes sense. That's the Politan theorem. based on years of experience in courtrooms across America. Michael Garnett, Vinny, if you were prosecuting on this case, would you have sought murder too? Seems like Commonwealth overreach there with the cards they had. Yes, this is a conversation we've been having since the beginning. And I have said, I'm on record saying I would not have under these circumstances. I would have leaned into the alcohol more. I would have leaned into the driving under the influence more than purposeful conduct. If I was given this case by my boss and said to prosecute it. Thank you, Michael. Mm-hmm. All right. I'm about 20 minutes behind, which is about right because my monologue was about 30 minutes. So we're catching up. Kathy Guidry, do you think the feds are involved because the SUV was taken to the Sallyport, bypassing two others, and there's missing time and video footage? That's the state police. It's the state police. They bypassed two other places they could have taken it, right? Were those other places, did they have the level of climate control that they had in the Sallyport where the snow would melt off? I don't know. But it's an interesting choice for the state police to bring it to Canton. But maybe they brought it there because there was room in the Sallyport and there was some level of heat there. But that doesn't help the prosecution in having to explain that. Anytime you're defensive and you've got to explain things that were done, you're not dealing from a position of strength. Yeah. Now, the interesting thing about closing arguments, okay, Sandra, Vinny, stop ignoring me. Come on, Sandy, I'm not ignoring you. Sandy, why did Turtle Boy go to this? Is this like a riddle? Why did Turtle Boy go to Canton and started trouble with those family waiting for your answer? I have no idea why Turtle Boy went there. He said he was going to get something to eat, but like, okay. He knows CF McCarthy's is right next to that place. Did he know that those people were going to be outside? I don't know. But clearly you have to ask him and not me because I have no idea. I did not speak to Turtle Boy about this. So, but thank you, Sandra. I know a lot of people were talking about this yesterday. A lot of people were talking about it. And the good news is it does not appear that any of these shenanigans on the streets of Canton will impact the trial. That was my only concern when this happened. That was my main concern. It just seemed like a crazy situation. Level of chaos. Dan Callahan, but considering what Karen said is part of testimony of those unreliable witnesses, then all the jury has is the experts, in my opinion. Right. So the alleged confession, and Dan is making a great point. The alleged confession by Karen is based upon the testimony of witnesses, but it wasn't just people in the house. It wasn't just McCabe. It was an EMS worker. It was a Canton cop. I don't know. Yeah, you can think they're all part of it, but you got to see that's the challenge for the defense in all of this is for the jury to believe that all these people would lie about it in much different levels of connections to the people in this case. Like a couple of EMS workers. Why would they lie about it, right? So that's where the defense has a challenge in undermining the credibility of some of those folks, and where the prosecution is, again, going to lean into those statements and attempt to bolster the credibility of the witnesses who testified about hearing that. Eladia Lopez, you look great in blue. Department of Justice gave to both sides, not just the defense. Yeah, it was an open book. The defense used it, right? The defense used it. It wasn't like the feds were behind the scenes feeding stuff to the defense. No, the feds did what they did, and then they told both sides, we're going to let you see the results of what we found. And that's the way that played out. And at the end of the day, it didn't help prosecutors. Hayden Kane, how come one of those shoe sole is very dirty and the other is almost brand new? They're both pretty dirty if you're looking at them. I'll make them bigger for you. All right. They both look pretty dirty. One's a little more dirty than the other. But even the white backdrop that they're on is dirty as well. So they're both used. If you want to make the argument that they're from two different pairs of shoes, you can. I don't know if the jury's going to buy that. Thank you, Hayden Kane. Big girl for life. Looking forward to tonight's show. I'll have a lot to say. Big show tonight, 8 o'clock, Court TV, your front row seat to justice. Closing arguments. All right, scrolling. Trophy wife. I think Higgins triggered the feds because he used a federal agency's tool to extract his phone. I'm shocked they are all still employed. The story behind the feds. I will just say this. The nature of this case and the aggressiveness of the defense and the snowballing of what was happening at all these court appearances, I think triggered the feds, right? Things were coming out. There was like this public outcry to a certain extent by some, and then the feds took a look. But the bottom line, like it doesn't matter at this point for this jury, it doesn't matter why. The only thing that matters is what came as a result of it, which is additional evidence that the defense used in this case, which without that investigation, they wouldn't have had, they wouldn't have used, and they wouldn't have been able to argue about during their closing arguments. Matthew Mazzarella, in this particular case, do you anticipate that a not guilty verdict from the jury would result in a swifter, prolonged deliberation? Okay, I think it's always easier for a jury to come to the conclusion of not guilty. So I think not guilties, generally speaking, can come a lot quicker than a guilty. I think it's easier for a jury to collectively feel comfortable saying not guilty than saying guilty. But there's a couple things in this case. Like John O'Keefe's family is in there every day, and you can see and feel their pain, and they are facing the jury directly. So that could give them some pause, knowing that their job is to find the truth, to tell us what happened. And for that family, it is to answer some questions for them. So I'm sure they feel that. And it's real and it's palpable inside this very small courtroom. So I'm if they get it tomorrow, I would expect Friday after lunch. If it comes in before then, I believe that'd be more indicative of a not guilty. Friday and beyond, I think it's a toss-up. But we'll see. We'll see. I always admit I have no idea. I have no idea what the jury is going to say. I've been in the game too long. And anyone who believes that they can predict what a jury will do in each and every case, and in a case like this, then, you have a 50-50 chance of being right. Texas Honcho, Vinny, you're so full of it. If you can't pick this one, you can't pick anything. I don't pick them. I've said this over and over again, that I cannot predict what a jury will say. I was inside a courtroom down in Orlando, Florida for 2.5 months watching evidence, listening to testimony about a defendant who lied about everything. And a defendant who basically, not on that day, but basically got a walk. So I can't predict it. Nobody can. You can have your best guess if you want, but it's not a matter of picking, because the dynamics inside that room are the seats they sit in are much different than our seats at home. The seats of people who are watching in the gallery, they're just different. And it would be difficult to predict a verdict without knowing one of the most important factors, which is like, all right, who are these 12 people? How well do we know them? Okay. If you wanted to introduce me to all 12 people, find out their life stories, find out, which way the way they see the world, their lives, what they've come across in their lives, how skeptical they are, how much interaction with law enforcement they've had. Maybe I could have a better chance of predicting, but without that information, how are you going to know how these 12 people? Lisa M, or is it Lissa M? When Lally brought up evidence they hadn't seen, they said none of it matters because it doesn't change the science and the physics. Crash Daddies for the win. Is that the nickname, the Crash Daddies? That's a nickname for the defense, the experts the defense used. So I wouldn't call them defense experts because they weren't paid by the defense, but the experts called by the defense. Kubi, what if members of a jury are friends with the McAlberts? Did they ask them if they were? Well, generally during jury selection, you hear the names of the witnesses, the names of the attorneys, and you're asked if you know any of them or if any of them are familiar. That's standard jury selection process. So they should be weeded out. If they are friends and they lied about it, and she's convicted, then you have a basis for a potential successful appeal. Laura Stevens, Lally lit himself aflame during cross. Embarrassing. When you battle an expert, and what happens with lawyers when you're dealing with expert witnesses is you have to study up and you have to become as much of an expert as the experts themselves. And you see this a lot in civil cases where they use a lot of experts in civil cases, more so than in criminal cases, where the lawyers know this stuff inside out. So a lawyer that does medical malpractice all the time gets to learn a lot about medicine and becomes an expert, his or herself, in it to a certain degree, right? They're not going to do operations, they're not going to practice medicine, but they can understand it and explain it inside a courtroom. And in cases where you've got like experts and you're talking about something that maybe you didn't know about beforehand, you have your own expert teach you. That way, when it's time for you to question the other side's expert, you are prepared and you understand what you're talking about. That's how it usually works. Didn't really play out that way in this case. And that may have been some of what happened. Jurors don't always get it right. Explain OJ and the name we don't speak of that rhymes with Smathy Smanthony. Right. Exactly, Stark. Exactly. Yeah. Well, and it's not that they don't get it right. I think the way we have to look at it is the prosecution didn't convince them. The prosecution didn't take that evidence and push it over the goal line, right? Because the evidence was there in both cases. OJ, you had problems with the lead investigator. Sound familiar? Yes, that was a huge problem in that case with the lead investigator. But there was enough evidence, right? The DNA, everything else worked for the prosecution, but they couldn't push it over. In the Smanthony case down in Orlando, two things happened. One, the jury didn't like the prosecutor, and the jury liked Jose Baez. That was huge, and they felt like all their questions weren't answered, and the evidence was there to answer them, but the prosecution didn't answer it. The other problem in that case was there was evidence that wasn't uncovered until afterwards because of a bad investigation by the computer forensic team, where Casey Anthony, said her name, actually had incriminating searches on Firefox, which no one else in the family used, but they never searched Firefox. And the defense was shocked that they didn't use that evidence. So that was a mistake. That was a mistake in that case. Deborah, hopefully they look into the Alberts and McCabe's. Lots of trash to disregard. The facts prove her innocence. If it's not guilty, I expect nothing to happen. I really do. I expect nothing to happen. There could be civil suit, could be a wrongful death suit, something like that. But I don't think you're going to see anything there. I really don't. And if she is guilty, the appeals and all that will go on. But I think that ends all of that. All right, let's see. I'm trying to catch up. Almost caught up. Eladia, if I was told he didn't go in and MS supposedly I was the last person to see him, then I would ask the same thing. It's logical. If I was told he didn't go in, I'm not following that 100%. My apologies. But thank you again. All right. Everyone's talking about all of the feds having their eye on Norfolk County, right? Which is fine and good. But here, this is a specific grand jury investigation, not a general, like we have our eyes on Norfolk County versus the actual specific grand jury investigation. Two different things. And as I recall, the response or part of the explanation, again, I'm not into Massachusetts politics, though, that there was some politics allegedly involved in the animus between a Norfolk DA and the U.S. attorney at the time, who's no longer there. That's my understanding. But I'm not in Massachusetts, so I never did the deep dive into the politics behind all that. All right. Faces of meth. Vinny, do you still hate Karen Read? Hate. Why would I hate? What do you mean hate? What does that mean? In what regard? Like just generally hate her? I do not really know Karen Read. I just know of the allegations. Saw her at the courthouse, but I don't know her to hate her. So there are some defendants who I find a lot of disdain for, but I don't quite get it, Faces of Meth, but thank you. And I love that picture. Revolutionaries. Vinny, So don't you see the evidence prove that Read did nothing? Just stop it. Yeah, I'm getting hit from both sides right now. Amazing. Thank you, revolutionaries. Thunder Road Queen, Lally couldn't find a rebuttal expert regarding the dog bite. Interesting. No? Well, that would be one that you might want to. I think he's going to rely upon his case in chief on that issue. Kathy Guidry, appreciated. Nick Rocco, only 1 hour for each. Only 1 hour for each. That's interesting. You know, when you talk about closing arguments, um, 1 hour for each side in a long case like this, I believe the attorneys should take as a blessing. They should take that as a blessing. Because many times I've seen in long cases where attorneys go on way too long. And their message gets lost in the sauce. This way, both sides have to be sharp. They've got to be to the point, and they've really got to get to the heart of the case. So I think 1 hour is better. Here we go. Judge Melly. All right. I'm almost all caught up because I've got to leave. Cynthia, Lally should have had a rebuttal witness. Sunk. Thanks, Vinny. They included involuntary. Mm-mm-mm. 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 All right. Eladia. Supposedly. Oh, there we go. All right. Got to put the pieces back together. All right. I have to run here. Rick Hirsch. Vinny, don't you think Trooper Paul's theory defied common sense? I was left thinking, no way it happened like that. Well, and an expert, it's not about common sense. An expert is supposed to teach us something that goes beyond common sense. And that's what we didn't get from him. And that's where he came up short. And that's where the defense expert, the expert used by the defense, but not hired by the defense, was able to explain the process in getting to the conclusion, right? To me, this wasn't backed up. You were supposed to teach me why I should believe something like that. If I was the last person to see John, I would ask the same thing. All right, we've cleared that up, but I still don't know what it was reacting to, but that's okay. That's okay. My apologies, Eladia. I missed something along the way here. So I hope the folks who are watching and listening got it. Dreamer thinker. But when you get hit by both sides, you have 5% of the population on one side, 95% on the other. Essential note. Think of all the butt dials, red solo cups of bloods, and Trooper Paul asking what scientific evidence means. Dreamer thinker, hitting hard. It's not 5%. On my poll, I'll check the final numbers for today. 1 second. There it is. The final numbers today on YouTube are 8713, and on X, it's 8614. So virtually the same. So it's about 15%. Now, here's the deal. And the question is, if that's the way it breaks down in this jury room, where does that leave us with a verdict, right? Because it's not 100%. So if it's like 10 to 15%, right? That's like 1 or 2 jurors, will they be persuaded to go all the way NG? Or will they dig in for a mistrial? Or will they attempt a negotiation, a compromise to maybe the least of the lesser charges? That's the question. That's the question. All right. This has been amazing, ladies and gentlemen. Oh, Audie, did I hit him? Did I hit him? That's, if I was the last one to see him, that's what I would be thinking. Did I hit him? Did I hit him? I'm getting it. I'm getting it. And that could be an explanation for an alleged confession or questioning whether or not you did it. Great job. Great comments. Great debate. I know everyone's dug in, but here's what you need to do. Here's what you need to know. Number one, 8 o'clock tonight, we're doing this story. Tomorrow on Court TV, we're going to bring you your closing arguments. They'll be done quickly. Then we'll be in a verdict watch. When we're in a verdict watch, that means a verdict can happen at any moment. It's not like, oh yeah, verdict will probably be tomorrow, so I'll not pay attention until tomorrow. No, you need to pay attention. Like if I'm in a verdict watch and I'm on location, I don't leave the courthouse. I don't leave the courthouse to go to lunch. I'll have lunch delivered, or I'll wait till we get word from the court that the jury is on lunch, and then I'll go to lunch. I'll come back, because you do not know. I can't tell you how many times in my career where I've just been sitting there and someone's like, oh yeah, maybe the jury has a note or something. I'm like, well, how do we know it's a note? How do we know it's not a verdict? How do we know it's not a verdict? And sometimes it's a verdict. I was covering a case in Massachusetts, ironically, and it's like 5 minutes to 6 o'clock. Every day at 6 o'clock, the jury's being sent home to finish their deliberations. So I'm just going up to the courtroom because it's just about 6 o'clock, just to make sure that the jury's going to go home at 6. And as I sit down, they say, oh, there's a verdict. Like it just came out. It comes out of nowhere, because we don't know where the jury is in their deliberations. We don't know the process that they're using. We don't know if they're getting in there and they have a 4-person. They say, all right, let's just take a vote. Let's just take a vote, see where we are. And if they take a vote and they're 12-0, what do they do? What do they do at that point? Well, we can't go back that quick. Let's just talk about it a little bit. Make sure. And they talk about it a little bit. They make sure. And then they hit the button. That can happen. I've seen cases where a jury doesn't even vote. They get in there together and say, let's go through all the evidence. So then they take 3-4 days to go through all the evidence. Then they vote. So you don't know the process. You don't know where they are individually as they come together. So it can happen at any moment. So make sure you are always close by. Court TV has an app as well, so you can carry us with you on your phone. It's super easy to download. So that's it for tonight. I got to go get ready for the show tonight, 8 o'clock on Court TV. Thank you to Vinny's Angels, the Mod Squad, Frankie Figs, Gen X, and Melly for keeping law and order as always. So much appreciated. And I will see you tonight at 8 o'clock. And I'm going to see you probably all week as we are in this verdict watch, paying attention to what's happening in Dedham, Massachusetts. I'm Vinny Politan. Hit the like button. Make sure you subscribe. Hit the bell. And have a great day. And don't forget to hug the kids.